Para Español, oprima el número 9. Thank you for calling Judge Goodwin's office, located at 6831 Cypresswood Drive, Spring, Texas, 77379. Our business hours are Monday through Friday from 8 a.m. to 4:30 p.m. Why stand in line when you can get online? Did you know you may be able to handle your traffic citation online at www.jp.hctx.net? On our website, you are able to... Good morning. Thank you for calling Judge Goodwin's office. How can I help you?
Hi, this is Nanette Carly. I think I got booted out.
Well, did you call again?
I'm gonna try to log back in, I guess. I don't know if I'm in or out.
Is anyone here in this room?
Oh, wait, hello? Hello? Hello?
Yes.
Hello, yes, I'm here.
So I guess they put us in this room to talk about this case.
Okay.
I'm the attorney for Miss Alwyn. They just gave us this computer because we didn't know this was going to be via Zoom. So we are all here in person. So we didn't have a computer. They plopped us in a side room and instructed us to talk about the case before the judge talks to us about it. He just had some long speech about trying to get the parties to work out their differences before he rules. I understand there's many cases on the docket today. I don't know why. I mean, this must be something he does.
Okay. So, am I speaking with Mr. Newsom?
Yes, that's me.
Okay.
I can probably, I'm not familiar with this computer or how to work it. Let me see if I can get some kind of video. Do you have video on your end?
Yes.
You do? Okay, let me see what I can do here. Well, that didn't work, I don't think.
There may be a control on the Zoom in the little square where your name is, JP41. In that little square, if you hover over it, it may give you an option.
Yeah, I've pressed the button that says start video, and it's not. It's still black. The screen is, but your screen is black too. So
Well, I have something. Oh, well, yeah. Mine's black aside from my end. Yes, you're correct.
It might just be that
they're not giving us video. Okay.
Yeah, that's probably what it is. I don't know, but it's not. It doesn't seem to be working. I can see your name though. It says Nanette. So
yes, sir.
And I do believe that you are you. So
okay, good. I'll take it that you are you too.
Yeah. What are we doing? I mean, what are we going to do on this case? Let me start by saying, as I understand it, there was a purchase of a like a all-terrain vehicle or something for $6,000, and half of the money was paid, and then you were going to have to find the title, and then a little time passed and you couldn't find it, or you were trying to get it, and they ended up getting a bonded title, but $3,000 was still owed, so you sued them for $9,000.
The original, yes, was 6,000. They paid the 3,000 down. They never paid the other 3. And then I got some very nasty texts from your client and a very threatening letter. And yeah, I asked for what I asked for in my pleadings.
Okay. Did the pleadings also ask for the $9,000 and the return of the vehicle too?
I believe so.
Okay. Is there a theory on that? I mean, I'm trying to make sure I'm clear. That's
Well, this is a $17,000 machine. Okay, and it had very, very few hours on it. And it was in excellent shape. And I don't know what damage has been done to it. And since Miss Alwyn came to the table with dirty hands, unclean hands, I don't even know that if I get a judgment in this case, if I'll ever receive anything out of that judgment. If I do get the vehicle back, I don't know what damage may be done to it or parts may be missing or changed. She's had that machine for quite some time now. And and then in addition, whatever hours may have been put on that machine. So, yes, sir, that's what I'm asking. And I feel like it's reasonable.
Okay. Well, that they're not going to be doing that for any reason.
Who's they?
My clients, they're sitting right here listening to you.
Okay.
But I'm saying that because this court cannot award title to anything. This court that you've chosen to file this lawsuit in is a JP court. All they can award is money. And under a theory for breach of contract, they can only award you the benefit of your bargain. They can't give you triple damages or deceptive trade practice stuff. They can't do anything like that because, and not to mention, this isn't a deceptive trade practice case. It's a breach of contract case. So the sole thing that we would be talking about from my legal opinion would be the benefit of the bargain under the contract, less any offset for hardship experienced by my clients in trying to get a title to the vehicle. Now, that doesn't mean that you don't get money or that they get. It doesn't mean that we win. It just means that we have our position, which seems like a polar opposite of yours. But just conceptually speaking, we have to concede that we're here at the JP court. All this judge can do is award money. He can't award title to a house or a car because
Well, he doesn't have
power.
to award title. I'm not asking for title. I hold title.
Yeah, no, I know, but you said you wanted the return of the vehicle. He doesn't really do that. He just awards money. That's all he does.
Well, then I'll hear that from him.
Okay. Well, no, and I'm not advising you. I'm just saying we're in the JP court, so that's generally what we're doing in the JP P court. I mean, if you look at the citation that was actually served, it says small claims money damages. It doesn't say small claims return of property because I don't think that's an option. But anyway, so your offer is $9,000 and return the vehicle, and my clients should just be burned at the stake, right?
No, I'm not saying they should be burned at the stake, and they're not. Even if they pay the 9, that's only 12 they've paid in, and I would have never sold that vehicle on that day for that price had I known that I was going to have to fight for the money, or the money wouldn't be forthcoming as soon as I could get a title.
I understand.
If I was going to wait all this time for my money, I would have just sold it for what it's worth, which is about 15. So
I understand. Do you guys want to make an offer?
I made my offer in the letter
What is it? How much?
that I would pay her $1,500.
All right, that's their offer, is that they'll pay you $1,500 to complete the consummation of the deal, and we all go our separate ways. They get the title. That's it.
well, that doesn't consummate the deal. That's not even the other $3,000 they agreed to pay, that they've made me fight for, and that they've come in with unclean hands trying to sneak around and get a bonded title.
You keep using this term unclean hands. Why would you say that their hands are unclean?
Because she didn't honor her contract.
Well, that doesn't mean unclean hands. That's
Sure
well,
it
unclean
does.
hands is a legal term. That's not, that
Sure.
just means that they didn't honor the terms of the contract. People do that.
Exactly. That's what I just said.
No, that's not the same as unclean hands. The judge can kind of explain that to you when we talk to him, but is our offer rejected?
Yes, absolutely.
Okay, so we will tell them that we tried to talk about it, that we need to talk to the judge, and we'll be on hold for a while now. So, I mean, like, we won't be on the Zoom. I think they'll take us off the Zoom, and then the judge will call us up and put us back on Zoom whenever it's our turn. There, like I said, there are a number of cases here, and I don't know what order they're going in, but it could be a while. I don't know. Okay.
Okay.
And then everybody will get their opportunity to talk before him. He's a very reasonable man. He is a lawyer, so he understands stuff. Even though he's not required to be a lawyer as a JP, he is a lawyer, and he's very nice, very smart man, very reasonable. So we will take whatever he says, and that'll be our ruling. Okay.
All right.
Do you have any more questions for us?
No.
Okay. I will let them know that we talked and we tried and that we just were unsuccessful, and they'll call us when it's our turn. All right.
Okay.
Thank you.
Mm-hmm.
Miss Nanette, can you hear me?
Yes, ma'am.
Will you unmute, please?
Yes, ma'am.
All right. Can you hear me?
Yes, ma'am.
All right. So I know the judge just took a little bit of a break, but while he's doing that, he is going to ask for you to start your video. So if you're using that Zoom app, you're going to have to start the video.
Okay, right now or?
When we bring you back in. So do you know how to do it? So I want you to go ahead and start it now. That way I know you know how.
Wait.
And when the judge comes in, you'll be able to take care of that.
Did it work?
No, ma'am. So do you have
Let me-
is your camera covered up?
Let me try again.
So you may have to pop out the camera or.
Oh, well, maybe, no.
Is it covered?
No, ma'am. I pushed start video
Mm-hmm.
and there's no cover on. Now it says I can stop video, so apparently it believes that.
All rise. All right, thanks for your patience, folks. Be seated. Okay, does Austin have one right quick? Is this
Set aside default Austin.
okay? Yeah. Everybody here on Parker Cumberland, Bria Tate? Come on. How are you? Okay, so I've got a request to set aside, fair enough, another viewing. Miss Alwyn, or excuse me, Miss Carly?
Yes, sir.
Oh, I'm not seeing, I don't even see.
Your Honor, I don't know what is wrong.
I told her that we needed to have video and she wasn't.
She doesn't have video? She didn't in there.
She said she had video, but it's not working properly. I asked her about her camera being covered up or something along those lines, and she didn't seem. Miss Lynette, can you hear us?
Yes, ma'am. I'm sorry, Your Honor. I don't know what is wrong. The Zoom shows that The video is on, the camera's uncovered, I'm dressed, I've my hair done, I'm ready for court, I'm here on camera. I don't know why it's not working.
I'm getting some feedback here. Is that us? Oh, that's because that's,
This has got audio.
Okay.
Your audio is on. Is that why? I'll turn this off. The audio on.
yeah, it's, the speaker is right next to the microphone. Okay. Here, let's. Okay.
We'll mute yours, and then I'll.
Hello?
Yes.
You're on.
Can you turn it up, Hope? Okay, can you hear me, Miss Carly?
Yes, sir.
Okay, good. All right, much better. All right, so I was the fault here. Okay, so Miss Carly, this Judge Goodwin, I have read your petition, but can you kind of just give me a brief rundown of what you're saying that you're owed and for what?
Well, originally, Miss Alwyn came into this contract paying me $3,000 down, owing $3,000 when I found the title. Once I found the title, well, actually, that was, Your Honor, in May. I'm sorry, Your Honor, can I just ask about procedure here? Are we doing opening arguments, evidence, and then close? I'm not really sure how your JP court.
Well, all right. So here's what I want to do.
Okay.
Let me just go ahead and swear everybody in, and we'll just go ahead and proceed. Y'all, I'm guessing are y'all a million miles apart or 10 miles apart in your discussions? Okay. So, Miss Carly, where you are, and then Miss Alwyn, and then Mr. Taylor, or if y'all will raise your right hands to be sworn, please. Each of you solemnly swear any testimony you give today be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Okay.
Sir.
Okay. So, Miss Carly, go ahead and proceed and just give me your testimony about what makes up your claim for $9,000. Now, you didn't hear me say all this earlier, but in litigation, in civil litigation, which I've been doing for a long, long time, it's very inherently dissatisfying. Oftentimes two parties will equally leave the court being dissatisfied with my decision or the process. You know, I want to prepare the parties for that. There are two sides to this lawsuit, and y'all have asked me to substitute my judgment for yours, which again I'm happy to do, but it may leave the parties with some questioning about whatever my ruling is, and you don't have to agree with me at the end of the day. Neither of you do. But since y'all weren't able to reach that result on your own, again, you're asking me to substitute my judgment. At the end of the day, once I reach a ruling, you may have questions about, hey, how do you come to that? That doesn't make sense. And that's okay. But I just want to prepare you. There won't be any answers to that question. Okay. And so I'm not trying to frustrate anybody. I just want to make sure that you understand that you're asking me to take all the evidence for facts that y'all know better than I do, consider that evidence, apply the law to that, and then make a ruling, which I will do. Okay. And one or both of you may not agree with any of that. That's okay. All right. So Miss Carly, how much are you suing for? I see in your lawsuit $9,000. Is that right?
That's what my original petition was for.
Oh, okay. I'm sorry. What is the actual amount you're suing for?
Well, I would have never agreed to the deal had I known that Miss Alwyn was going to be coming in bad faith and that
So
I
I don't
would
even know
have
what
to.
the deal, I don't know what the deal is. So
Oh,
I don't know anything about your lawsuit, Miss Carly, other
okay.
than generally what you've included. So I guess I just need you to explain to me, if you can, how much you're suing for and why you feel that Miss Alwyn, your testimony as to why Miss Alwyn owes that to you.
Okay. So again, to clarify, Judge, because I don't want to waste your time or frustrate anybody, are we kind of doing opening evidence, arguments, and close all together, or?
Yes, yeah, it's a little looser than some other courts. If you're just having a bench hearing, bench trial, which is what we're doing.
Okay.
Miss Alwyn and Mr. Taylor and their counsel are here at the bench, ready to present their evidence. And so go ahead and just give me your testimony as to what you're alleging and how much you're alleging is owed to you.
Okay. So, as stated in my filings, Miss Alwyn came to an estate sale in May of 2020 and wanted to buy a Polaris, which is kind of a farm equipment. It has a dump truck on the back and also had a lot of extras put to it. It's originally $17,000 and only had a very few miles on it when it was sold. I was presented with a handwritten contract, which I agreed to,
You
accepting.
are selling it, Miss Carly?
Yes, sir, at an estate sale.
And is this something you inherited from someone who had passed,
Yeah,
obviously?
yes,
Okay.
yes, sir, from my
O-
father.
Okay. And how old is this Polaris?
It
And when?
it
Go ahead.
was a 2010 model, and it only had a few hours on it. I would say, and I think I have pictures, I would say less than 1,000, definitely. But she agreed to give 3,000 down and 3,000 when I found the title. Now this was May on May
May of what year?
2020, sir.
Okay.
And then in June, let me pull it up exactly. In June, I got word that Miss Alwyn was filing for a bonded title action. And
So did she give you $3,000?
she gave me 3,000 down the day of the sale.
Okay. And then you gave her the Polaris at that point?
Yes, sir. And
Okay.
and then on May 24th, I texted her and I told her that I found the pull away face stereo and that I hadn't found the title because I was in the middle of a move. It was an estate sale. So she knew I was moving. I told her it may be a minute before I got the title because I was doing an estate sale and moving. And on May 24th, I texted her and I told her I found the stereo face and I was still looking for the title. On June 8th, I texted again and said, sorry it took so long to get back. I've gotten moved and recovered and I've been looking for the title. Of course, it's lost in the move and I should have it in a few days. On sometime in June, she filed for a bonded title action and I was notified. And so I told her we need to meet up so you can pay me and I can give you the stereo face because she's filing for a bonded title. So give me my money. I'll give you the stereo. You get your title and we're done. And she asked, do you have the title, knowing that she had filed the bonded title action? I also, well, that's going to be a little bit later. So she continues to ask me for the title, and so I told her that if she made me fight against the DPS action, that I would be filing in court. And I then proceeded.
The DPS action.
The bonded title that she
Yeah, go ahead. Well, hold on one second. What's a bonded title? Is it when you can't produce the bond, when you can't produce the title, it's sort of a bond
So
that you,
post a bond so that if the true owner comes forward, they can claim it. And you post a bond against any kind of claims that may come up.
okay.
In this case, it would cost $400. You have to, they assess the value of the vehicle and you pay a 5% or something.
Okay.
And
It's like
I believe, Your Honor, that you have a copy of that handwritten contract. I'd like to enter that into evidence.
Maybe, I don't know.
I did send it with my pleading, sir.
Okay. But go ahead.
And then on, she refused to meet with me, and we kind of bantered back and forth on text, and then I sent her in on September 3rd, I sent her a notice, demand, and opportunity to cure. And then on September 4th, I got a response from her that I also included in my filings. I'd like to enter these into evidence as well. Her correspondence of September 4th, she does state that we had a contract and that it was for $6,000, and she gives me two options. And to remedy the situation, she says she's willing to pay $1,500, which is half of the remaining amount, upon receipt of the title. And then she says option 2 is that I give her back $3,000 plus the money she has spent on repairs and fees for the bonded title, a total of $4,900, and I can have the vehicle back. So accepting half of what she agreed to or paying her money, neither one were good options to me. And
so did you ever get the title? Did you ever find the title?
Yeah, well, after when I had to file against her bonded title to stop it, and I had to file this court case in order to stop it. And I warned her in my text if I had to do that, that I would be filing for damages and whatever I could get. And Your Honor, I would have never sold this vehicle if I'd have known it would take 2 years to get paid.
So did you ever get did you ever find or locate or
yes, sir. Yes, sir. Now, yes, sir.
To get a replacement title?
Yes, sir. I have the title, and she knew I had the title. Okay. And I went down. It only takes a few minutes, sir, to go to the title office and get a copy. So I did that, but I had
to. Is it done at the tax assessor? Is that where that's done?
It's done at the DMV, but
okay.
you know, when she notified me that, or when I was notified by the DMV that there was a bonded title action and she had already paid for it, you know, I was just going to let her have that. But then when I saw, you know, okay, well, I need to stop that bonded title action. I need to file a case, blah, blah, blah. I went ahead and went over to the DMV, which is difficult for me because I'm mostly bedridden. And I did get a copy of the title, and I made Miss Alwyn aware of that, and she still refused to pay. Um, and
What did she give a reason?
well, let me look at the letter here that she wrote. She says, I informed you you still had not found the title and would have in a few days. I heard nothing from you and now have a UTV that I've purchased and spent to repair and no title. She says that she filed for the bonded title. She says almost 2.5 months later, but that's not what the paperwork will show. And you know, even if it was 2.5 months, well, our texts show otherwise, but even if it was, Your Honor, in her original contract, she stipulated no time constraints on me. She simply stated when I found the title, she would pay me. And when she filed for the title action, I assumed she was going to get the title and, you know, but then she refused to meet and give me the stereo and pay the money. So I went ahead and filed all these actions. So even today, when we came into court, she's still offering only half of
So,
your.
yeah, it's not appropriate for me to know what those negotiations are. It's just a rule of evidence.
Okay, well, in her letter, she's wanting to only pay half of what she agreed to. And considering that Miss Alwyn knew at the estate sale that it was an estate sale, she knew I was sick. She saw I was surrounded by people and overwhelmed. She knew I was moving. We texted about that. She knew it would be some time to get the title. She states in her letter it was only for family use, so there would be no rush to a title. In addition, in March of 2020, Governor Abbott waived vehicle registration, titling, and parking placard regulations in Texas. So even if she wanted to sell the vehicle or whatever she wanted to do with it, there was no restriction on her doing anything because everything was waived due to COVID-19.
Yeah, I don't know that she would have had freedom to sell it. I don't think that's not what.
Well, certainly
that's
not until she paid for it, but
Well,
my
that's
point
that wasn't the
is,
governor's directive on that. All right, so okay. Okay, so I think I have enough there, at least initially, Miss Carly. Okay, Mr. Newsom, do you
Yes.
want to? Yeah,
Yes. So the first thing I'd like to say is she's making it sound like they just snapped a judgment and went and got a bonded title and they had no intent to pay. They actually contacted her several times. She mentioned that she had the radio. Mr. Taylor was going to go get the radio. She said no, and she kicked him off the property. And then they got the bonded title, but it was in August 12th, and that's a copy
Okay.
of the bonded
and
title.
when
Objection.
this overruled?
Okay.
The sale was in May.
Correct.
Okay, so like 3.5 months later, you went to do a bonded.
This is a copy of the Facebook post where it shows the list of the ad and the address where the estate is going to take place. And actually in the photos is a copy of the vehicle. It's there in the photos. The Polaris is in that second photo there. And it was mentioned as a garage sale. But they went to this
It's that red thing right there?
Yeah, in the corner behind the golf cart. The vehicle was not running at the time. They had to go get a battery charger to kind of get it started up. And then once they did, it didn't run very well. That was the purpose of the negotiation for the price. They didn't know what they were going to have to put into it, so they agreed to a price.
Right.
We do have a copy of the contract, Judge, if you do not.
Yeah, I saw that. Yeah, so
So-
I've seen your contract. Your point is that you weren't given the title quickly enough. Is that
Correct. I negotiated the deal with her,
okay?
right? She told me.
And you may need to keep your voice up just a little
She
bit.
told me that she had the title in the safe and that she was overwhelmed with people. So I understood that. I said, I'm gonna give you $3,000. I'll come back tomorrow and get the title from you. That was the agreement. I figured she would have had the title right then selling it, but she didn't. So I said, well, I give you $3,000. I'll come back tomorrow and get the title from you. When everybody leaves, you can find
And
it
the
in the
radio.
safe and the radio
Or-
and give you the rest of the money.
This is in May.
This is in May.
Okay.
2020, right?
Right. So we text her back and forth. I went the following Saturday. She texted saying she had the radio. So I went back the following Saturday to get the radio, to give her the money and pick up the title. When I got there, I said, I'm here to get the radio and get the title and give you the money. Get off my property. I'll call you when I get the title. She kicked me off the property. So when she did that, I said, this deal just doesn't seem right. Went, filed for the bonded title.
2 months
But
later.
that was 2 months later.
2 months later. We give her time. We have some text messages back and forth from her with the time frame. You know, and her, even in this text message, she says she'll have it in a couple days.
When
It was a month later.
Well, okay. So was the title in somebody else's name, Miss Corley? Miss Carly?
No, sir.
Okay, so when you were describing it as an estate sale, you were the owner on the title. Is that right?
Yes, sir.
Because we have
Okay.
a copy of the title.
So
It's in Mr. Taylor's.
Oh,
She shows the previous.
but this is the
That's the one that they have to purchase, the bonded title.
this is the bonded title, but this is in your name.
Yeah, they're.
Okay.
Your Honor, I don't know
Who's on
what,
this contract? Yours though?
Correct. Miss
Okay.
Alwyn and Miss Carly.
All right.
Your Honor, I don't know what you're looking at.
I'm looking at the bonded title.
It was I put a hold on that bonded title action after Miss Alwyn refused to pay, and I have a letter from the DMV that says there was no bonded title action, so I thought that Miss Alwyn had withdrawn her action, and I told her again, let's meet, and she refused.
I sort of did this earlier, and maybe Mr. Newsom has more experience in me at this, but look, so I'm hearing your evidence. Y'all are asking me to render a judgment. And I wish I had started with y'all earlier. I know that you're on Zoom, Miss Carly, so that made it a little more difficult. And I appreciate Mr. Taylor and Miss Alwyn for being here and being so patient all morning, because it's been a crazy one. But I wish I would have been able to start with this case earlier, because I think it is sort of resolvable more than some of the other ones that I've heard here today. Your lawyer's shaking his head, and y'all are saying no, and
Well,
your lawyer and I agree.
Yeah, I don't want to speak over
I
the
think
court,
I think it is resolvable. Now, he's working for you, right? He's working for you, but smart lawyer who's done mediations, right? The point is like, okay, so you've got this contract. You had to go through all this hassle. You didn't get the title like you should. So you had immediate possession of it. I don't know if you used it right away,
Well, it had needed 3,500 in repairs.
So, okay, so you had some repairs, and it's, at least looking at this thing in the garage, it looks like a really nice piece of equipment, and I'm sure it's even better now. you
Judge,
know,
I have some
what,
suggestions.
Yeah.
If it would assist the court.
if you're okay with me, Miss Carly, sort of wearing a mediator's hat here for a second, I'll take off my judge hat and put on a mediator's hat and see if we can find a reasonable solution to an off-ramp. Are you okay with that?
Yes, sir.
You don't have to be. That's okay. You know, you can tell me no. I won't take offense to it. But you know, let's suppose you get a judgment. Let's suppose it's for some amount. You may not see any of those proceeds for years, and you would have to do any judgment enforcement. And there are judgment enforcement mechanisms, but you know, you would have to do it. It's not like if you got a judgment for any amount, let's say, and I don't know if you would, but if you did, you might spend $1 to try to get $1. So, so that's what I'm saying is I hope that there's an off-ramp here. And again, I wish I had had this case earlier, because of the many of the cases that I heard here today, this one actually seems the more easily solvable, right? I'm not taking away from the frustration that it's taken to get to this point. You've obviously retained Mr. Newsom. That's not cheap either. He sat around here all day, and I'm sorry. Yeah, that's kind of been an issue. So
I'm doing this case pro bono. These are my friends.
well, it's good to have some friends. All right. So, and it's good to be honest, but
Yeah. Well, I mean, I
So-
don't want to give it.
well, sure, fair enough. I appreciate that. So Mr. Newsom has sort of an idea. I haven't heard it yet. Are you willing to listen to it, Miss Carly?
Sure.
Okay, go ahead.
Okay, thank you, Judge. To start with, the claim was a little strange to me as it began when I first saw it, because it requested damages in the amount of $9,000.
Right.
It had a contract for $3,000, and it also demanded the return of the vehicle. So it wanted to be like, she didn't want to be made whole. She wanted everything and wanted it all back and wanted.
Right.
So
Yeah, and I'll just let you know at the outset, Miss Carly, sorry to interrupt you, sir. You will not come close to $9,000, even if there is a judgment in your favor, just to let you know. Yeah, I don't find, even giving your pleadings the broadest, I don't see any DTPA or anything like that. I'm not sure how you got to 9,000, but treble damages aren't going to be at issue here. I don't find any bad faith or anything like that. So go ahead. I just want to make sure that sort of our brackets are
right. And
set.
when I was talking with Ms. Alwyn and Mr. Taylor about the case, we were talking about whether there were any expenses incurred and whether it was reasonable and justifiable under the circumstances, and was there a long enough amount of time between the time when there was supposed to be execution of the contract and whether anybody's performance was excused or anything like that, because I was looking for some kind of legal
Like the $400 to do the
right,
right,
And
which you have not gotten back, right?
No.
That's the cost to do that.
correct.
Okay,
Yeah.
go ahead.
And they both had to miss some time from work. They were going back and forth with this woman that went on for 3 months. They put repairs in the vehicle. She was demanding the vehicle back to their severe detriment, because if she got the vehicle back, they wouldn't be compensated for that. So I was suggesting when I've talked to them, and I'm honest, somewhere between the $3,000 and the $1,500 that they're trying to recuperate for the costs that they've incurred is probably a reasonable resolution, provided that Ms. Carly can provide title. I mean, like, this is what got us here.
Like
She's-
the title,
Yes.
which you have, right, Miss Carly?
Yes, sir.
But again, Judge, she made assurances to us before that it was in the
Right,
safe, and then
right.
it wasn't in there, and then they did a bond
Okay.
title, and only then. did
Your
she
Honor,
start-
it's in my lap right now.
Oh, okay, good. Well, okay, and I don't have any reason to doubt you. So Mr. Newsom actually brings up kind of, his point is well taken here today in that, I think that this is a settleable case, Ms. Carly. I mean, is there some amount between that 1,500 and 3,000 that you could live with? And, and then you have a bird in the hand.
Absolutely not, Your Honor. That's not even
I wouldn't
honoring
die on
the
this. I wouldn't die on the hill, Miss Carly. The problem is that let's suppose you get a judgment for something, and you very well might. You may never see a dime of that money because you would have to enforce it.
which is why, Your Honor, because Miss Alwyn does come with unclean hands, she
Yes,
made
she
the
does. It's not in
contract.
pleading, it's
She
nowhere.
did not stipulate in the contract any time for me to pay. She accepted in my text that
You mean give her the title?
yes, she didn't. Yes, she didn't
So what's
stipulate.
a reasonable time to get the title to somebody, Miss Carly? What would be a reasonable time after a sale of a vehicle like that?
When you said the title was in the safe.
Yeah. So yeah, what do you think the reasonable time might be?
Well, by June, she had already filed her action.
I don't think so. I see it's in August.
No, I received the letter from the DMV that she was attempting in June, which is why I started communicating with her to come get the pull away face stereo and pay me my money. That's when I communicated that because she had filed that action or attempted to. And if I had not thought that I would get my money in a timely manner, I would not have sold that vehicle for that price at that time. If I'd known it was going to take 2 years to get paid, I would have taken my time
How
because
much have y'all put
the
into it?
vehicle was worth 12. I'm testifying here. Hello? The
Okay,
vehicle was
so
worth, Your Honor, 12 to 15,000. Minus
a
3,000.
10-year-old Polaris,
What?
a 10-year-old Polaris was worth 10 to 15,000.
Yes, sir. Yes, sir.
So I
Absolutely.
know
It
Polaris.
had
I've
many
been doing this a long time, and the depreciation on it would seem to be based on the amounts of cases that I have heard that would not seem to be. Yeah, this 6,000 amount seems to be a fairly reasonable amount. You know, I'm not.
I would have
So,
never
so
sold it
there.
for that amount had I
So
known it would take me 2 years to get paid.
So
And
are you interested in buying it back for the amount that they've put into it, the 3,500?
Well, plus the
no,
3,000.
sir. Your Honor, they bought the vehicle as is. So any money that they put in it is on them. They
Fair
bought it
enough.
as is. And
They did it in anticipation of getting the title in a pretty reasonable time. And then once they put the money into that, and
well,
they don't have the title, then
in
their
light of
position would be to then try to get some assurance that they have ownership of it.
Your
hence the
Honor,
bond title action.
in light of the fact that Governor Abbott had suspended registration and titling, a couple of months, I think is fine. They knew that I was moving. We texted about that. They knew that I was sick. They saw me ill that day.
Well, here we are, Miss Carly. Here we are. Now, what do we do?
And
Right? So
Your
is
Honor,
there some amount between the 1,500 and the 3,000 that you could live with?
no, sir. I would want over and above because this has cost me.
You're not gonna get that. I'm just
This-
telling you right now.
This
That's not
has
gonna happen.
cost me. It hasn't cost them. It's cost me.
Miss Carly, the most you could possibly even hope to get out of this case, based on your pleadings, would be the amount remaining in the contract. That would be the most you could hope to get.
Well, I would certainly ask for that because they were presented title. They did not give me a timeline on producing it. There were waivers against needing it at the time, and that's why I would also ask for whatever relief may be available to ensure that Miss Alwyn pays this judgment in a timely manner
Oh,
so as
well,
not to
let's-
cause
let-
any further damage to the plaintiff,
Miss
such
Carly-
as ordering that the plaintiff be made to pay within 30 days or found in violation of said order and also found held in contempt of court.
I need you to listen, Miss
I,
Carly.
I'm just trying to finish my statement.
Yeah, I don't need to hear it. I just need you to listen. Here's the thing, is that let's suppose you end up with a judgment, and you might for some amount, but I don't order anybody to pay within 30 days because that's not how it works. You would have to seek to enforce that judgment, and that may take you months or years, or there's processes to do that, but you would have to research that on your own. And so that's what I'm saying, is that it might be worth having a guarantee, Miss Carly, to take some amount less than you feel you're owed, just to have the guarantee of getting that money. So I can't answer that for you.
Your Honor, if I'm not made whole and given damages by this court, I will appeal.
That's fine. Okay. Well, I'm wearing my mediator hat. Is there some amount that you are saying, that you could live with? Okay. So if for some reason, if Miss Carly, they would be willing, I don't know if they are, if they would be willing to give you 2,000 even, would you be willing to accept that?
No, sir.
Okay. Fair
I
enough.
don't think asking them to honor their contract is out of line, Your Honor. I honored my end. I've produced a title. It's free and clear. And I did it before the title registration was lifted. The waiver was still enacted when I got that title.
Is there any other part of your statement that you would like to read? I want to make sure that you feel completely heard today, Miss Carly.
Yes, I would like to, in light of the fact that that Miss Alwyn filed for title action a month after and refused after I told her that I had the title, still refused to pay, comes today, still refuses to pay the initial amount. I would ask that the court assure that Miss Alwyn pay in a timely manner or be found in violation of the court order and held in contempt for such violation. And I would ask that that be paid in 30 days and that the court enforce its own orders.
So, Ms. Carly, let me just kind of explain a little procedural stuff to you. And you may know this, but I don't know that you do. So I'm about to enter a judgment for you in an amount that you're not going to agree with. But there is no order from the court to pay. There is an order, there is just something that says judgment. You then become a judgment creditor. Ms. Alwyn then becomes a judgment debtor. Any judgment enforcement you would have to seek to do on your own. All right?
And I'll do that. I'll be happy to do that.
But let me just advise you, Ms. Carly, that may take you a long time. It's potential you may not see any of that money. I don't know. And it may take you months or years to see that amount. So that's why I always encourage parties when they're willing to settle their case, because right now they're willing to pay you to the bird in the hand to get that money. You will actually have that money. And I had suggested if they were willing to come up to $2,000, would you be willing to accept that? And your position was no. Maybe that's changed, Ms. Carly, because you may never see any of the money.
Is that a threat, Your Honor?
From them?
I object.
Yeah, from whom?
I don't know.
No, it's not a threat.
That's why I'm asking.
Well, who are you perceiving the threat from?
I don't know. That's why I'm asking. Is that a threat? And if so, from who?
No. I guess I just need to say, because some people, they're judgment proof. I don't know the financial situation of the Allwins. So all it is you are a judgment creditor. It doesn't mean that, all of a sudden I order them to pay within 30 days or anything like that, Miss Carly, so I guess I just need to know if there's any willingness of you on your end to work out any solution between the 1,500 and 2,000. Maybe they're, on their part. Is there any willingness on your part, Miss Carly? And there doesn't have to be,
No.
but I think it's okay. Fair enough. Any thoughts?
Judge, we're trying to be reasonable.
Okay, okay, Miss Carly. Did Mr. Taylor come to your property like a day or two after the sale and ask for the title?
He
The radio?
he came and asked for the pull away face stereo
Okay,
and the
I
title.
heard title at the
And
same.
title, so we could pay. That's what she
Oh,
wanted.
okay.
And I was in the process of moving, and I told him that. And they knew that from the estate sale.
Okay. All right. Well, my hope was, look, y'all can still try to get this figured out after today. Miss Carly, I hope you do. I'll enter it. I'm going to enter it. And again, Miss Carly and Miss Alwyn, I'm not talking about anybody's reasonableness here. I think that's not in question. But I do know that, again, when I enter a judgment, y'all have asked me to do this and you'll have questions, but I just want to prepare you. There won't be answers. Okay.
Can I make one more statement, Your Honor?
Yes, ma'am.
I think it's fairly understood when somebody's doing an estate sale or a garage sale that they're doing it because they're in some kind of financial need. And I've waited already
maybe.
2 years for my
Okay.
money. And I've suffered over that.
Okay.
I've suffered greatly. I was giving up. I was selling the vehicle for half the price I would have normally sold it for at the estate sale. I would have not done that had I known this is what I had to face.
Sure. Look, but I don't, from Miss Alwyn's perspective, she didn't anticipate that she was not going to have full and complete ownership for some time. And I'm just telling you and then had to exercise some expense.
She had possession of the vehicle from the very day.
True.
And we
So-
were under the governor's waiver. So there was no inconvenience to them to wait.
Okay, so yeah, and from their perspective, they're not agreeing with that part, Miss Carly, which is fine. They can disagree with you, but so I'm about to enter something, Miss Carly. Do you want to? If they may be willing to give you $2,000 right away, are you willing to take that? And then you have the guarantee of getting that.
No, sir. If I have to pursue it, I'll make sure I get damages.
Oh, okay. Well, I'll.
Fees and cost and everything. Yeah.
Okay, well, sorry, we could not work this out. I'll enter for Miss Carly for $22.50 plus court costs, okay? Y'all can still try to negotiate a settlement out of this.
Your
I hope you
Honor,
do.
that doesn't even honor their original contract.
You don't have to like it. I tried to get y'all to figure something out on your own. I told you.
Okay, I will appeal.
Okay, have a good day, ma'am.
Thank you.
Yes, ma'am. Thank you, Judge. Hold on. Okay, are we completely logged off? Let's, can we get completely logged off?
Yeah.